box, Mr. Frankham.
Thank you, Your Honour.
You had some questions, yes.
Very quickly.
Yes, that's all right.
Chief Commissioner. Mr. Franklin, my name's Mr. Hall. I'm acting on behalf of Officer MTS1 in these proceedings. Just picking up from where the Chief Commissioner asked you some questions, is it the case that of all the case studies that you reviewed or your team reviewed, there was none where there was a personal interaction either by a video conference or a visit to the police station or visit to the area that the young person was being held by the police?
That's right. It was all over the phone.
In all those matters. And how many did you review?
I can only give an estimate. There were 2 filing cabinets. I'd estimate between 300 to 400 files all up.
And those, I think in your evidence you gave a view as to how many you did per shift. The interaction with just a general interaction with a young person, what would be the estimated time that you might spend on the phone with the young person?
It's really hard to say. It varies so much. It can be anywhere, but I'd say at least 5 to 10 minutes. But some young people, it can go up to as long as 30 minutes on some occasions and even longer.
Okay. And is there any note on the file to say how long the interaction was?
There's a place on the form that records the time of the call and the end time of the call. It also records if a message is received and we're calling the police back.
And just the last point that I asked the Commissioner for leave to ask some questions. In relation to that form, is it a one-size form for ages between whatever ages there are, or is there a differentiation of any forms that you use?
No, it's the same form used for anywhere between 10 and 17. And obviously that there are parts of the form that only apply to young people of certain ages. For instance, if we're giving advice in relation to dolly Incapacts.
I did want to go into that area.
Yeah.
And just in relation to the young person's understanding, do the officers under you or you have any specific training in relation to gathering that understanding?
What do you mean by?
How do you determine that the young person on the other end of the line has understood the complex issues that you're discussing with him?
It forms part of our training of dealing with young people, not just on Youth Hotline, but on a day-to-day basis in court. Particular things, for instance, you might be asking the young person to repeat back to you in their words what they understood you meant. And you do your best that way to make sure that you finish the call with the young person having the best understanding that they can.
And that's an important issue, isn't it?
Yes.
Thank you. No further questions, Chief Commissioner.
Yes, thank you, Mr. Hall. Anyone else? Yes, Mr. White.
Yes, thank you, Chief Commissioner. Mr. Frankham, just in relation to your relationship with the young person that you're talking to on the phone, it's an advice service, is that correct?
Yes.
So do you agree that it's not necessarily an ongoing legal relationship you have with that person? It's just a temporary relationship in terms of the advice you give them. Is that correct?
It's a temporary relationship in terms of the advice, but can extend further than that. For instance, if the young person is requesting us to do something on their behalf, such as passing on their instructions, or it might be speaking to a third party, such as a support person or a youth worker or whatever it may be.
That would be dependent on further instructions coming from the young person, correct?
Yes, we don't take those steps unless we have those instructions first.
So in the absence of any further instructions after your phone call to the young person, as far as you're concerned, whatever relationship you had with that person has ended, correct?
For that call?
Yeah.
Unless yes.
And in some cases, and you've given examples in your evidence where you might meet that person again at court and they engage legal aid and then a solicitor-client relationship commences, is that right?
It's in relation to the charges?
Yeah.
That's correct.
But that solicitor-client relationship hadn't been created at the time of the telephone call, had it?
Well, I say there is a solicitor-client relationship in relation to the advice and the information provided to police. It's just a different type of relationship than a client solicitor relationship.
But
might
not
be
in
in court.
terms, sorry to interrupt you. But not in terms of an ongoing relationship or a retainer for the purpose of the particular matter.
No, not unless something comes up where we're required to do further work.
All right. And you'd agree that in terms of your involvement with the phone call, that's often done in the absence of a support person?
We always speak to the young person first prior to speaking to a support person. It's a direct client and relationship, and we need their instructions to speak to the support person. But it's our best practice, and we try to, in all advices that we give, to speak to the support person if possible.
But you'd agree that there'd be some cases where you speak to the young person and there is no support person available at that stage?
Yes,
So you give the advice to the young person in the absence of a support person, correct?
it depends on the occasion. There are occasions where if I speak to an officer or a custody manager and they say the support person is 5 to 10 minutes away, we will instruct them, we'll call back when they get there. If they tell me we're unlikely to be able to get a support person at all, or they're unable to give an ETA on when the support person is going to arrive, we will speak to the young person, and we would, as a matter of standard practice, say, can you please call back when a support person arrives.
Let's just assume for argument's sake though, when you're talking to the young person, there's no support person on the horizon at that
Yep.
stage, that situation would happen, wouldn't it?
Yes,
And you'd proceed to give the young person advice, correct?
that's right.
And you'd agree, in your experience, Mr. Frankham, that after that initial advice, when a support person may ultimately appear at the police station, things can change, correct?
That's right.
Support person might be a parent, correct?
Yes,
Might be a guardian,
yes,
and they might have their own views about whether the person should agree to an interview, correct?
they may.
And they may have their own views about the legal advice they were given over the phone, correct?
Yes,
And that person might override whatever views the young person had about whether they should have accepted that advice, correct?
yes,
And on the assumption that that's happened and the police offer that person an interview, you can see why the interview would then take place, correct?
I can see why it happens in those circumstances.
Yes, nothing further, thank you.
Yes. Any,
With the Commission's leave, could I ask a number of clarifying questions?
yes, certainly. Thank you, Ms Lua.
Mr Frankham, in circumstances where or a youth hotline solicitor speaks to a young person where there's no support person present, is there a standard practice of what's conveyed to the police in those circumstances?
There is.
And what is that?
It's normally if they're expecting a support person, to call back when the support person arrives at the police station.
Do you have an expectation that there would be a call back to the youth hotline once the support person is there?
Yes, if we've spoken to the police and made that request, we do have that expectation.
Are you able to say whether that occurs in every case or whether there's a practice one way or another about that?
It doesn't occur in every case. It occurs in many, but there's often many it does not occur. We also have a standard practice for our solicitors. If there is no callback after a certain amount of time, they may follow it up with a further call to the police station.
You've been asked some questions and given some evidence that's dealt with these concepts of advice and instructions. Could you just clarify how you understand the youth hotline process to work in terms of the advice that's given and the instructions that are taken?
Yes, the advice can be wide-ranging, but given the issue here, I'll speak to the right to silence. So we go through with them, and in my view, that's what the advice is, explaining to them what the right to silence means, explaining to them what their rights and obligations are, speaking also to the support person about the same types of rights and obligations, and then having a conversation with the young person. Do they want to exercise that right? And if they do, asking the young person, do you want me to speak on your behalf to the police to convey that to them. And that's what I consider instructions when they say at that point, yes, that's what I want you to do.
So the advice portion, if I can put it this way, is from the solicitor to the client,
Yes,
and then the client provides the solicitor with instructions.
that's correct.
And then if there's permission to do so, those instructions are then conveyed to the police officer. Is that right?
That's right.
That's the process as you understand it
Yes.
to take place. Thank you. They're the questions I have.
Yes, thank you, Ms. Lewis. Any other applications? Mr. Fernandez?
I'd like to ask you some questions, just taking up some of the questions you were asked about support persons and what happens when support persons arrive at the station. Do you still have the legal aid submission there with you?
I don't.
And have it brought up electronically, or if it happened to be physically.
Yes, perhaps it could be brought up electronically, please. This is MTS 65.
Could be that the documents in the hearing room, so just have that handed to Mr. Frankham.
Thank you.
Could you turn, please, to page 14? At part 4.8 on that page, the heading relates to change of mind and failure to follow up the hotline.
Yes.
Can you see that? What's set out in legal aid's submission starts with this. A support person plays an important role in assisting a child through the arrest process. In some cases, however, the support person will have fundamentally different ideas about, quote, what is best, end quote, for the child that do not align with their role or consider the full range of legal consequences. Is
Yes.
that something that you have personal experience of, that very situation described there?
That's correct. I have.
What sort of situations does that take place in?
Normally, in my experience, it's normally involves an advice where a young person is going to be charged, where you give them the advice about their right to silence. The young person wants to exercise those rights. You then speak to a parent who wants the young person to be truthful and honest and speak to the police about what's occurred. That's normally the standard scenario in which it occurs.
If you turn, please, to page 15 of the legal aid submission. What's set out there is relevantly as follows. This is at the very top of the page. Unlike a solicitor who acts on direct instructions and with full understanding about the range of legal implications, a support person will sometimes exhort the child to make admissions against interest and against legal advice. Is that something you have personal experience of?
It is.
Is it the case that you have any control over who the support person will be who goes to the police station to support a young person?
No control.
Do you make some inquiries, if you have a chance to work out if there's any fundamental conflict between the position of the support person and the child?
We do. That's part of our standard practice. If we get a situation where a support person is of a different view to what the young person wants, we'll spend some time trying to speak with them. Often it's the case where, as is in the submission, the parent normally doesn't understand the legal consequences, and we can often speak to that, and they may change their mind.
Might be a parent or a carer, support worker, youth worker, or anyone else who's
Right.
there to attend. If you look at the submission, you can see in the second paragraph on page 15, what legal aid sets out is its awareness of several cases where, despite instructions being clearly communicated to police that a child does not wish to be interviewed, that following separate conversations with a support person, the child has, quote, changed their mind, end quote, and decided to take part in an interview. Is that correct?
That's correct.
I want to ask you about some questions you were asked about training, particularly the training provided through the Legal Aid Children's Legal Service for solicitors who take part in the youth hotline. Are you yourself involved in that training?
Yes, I am.
what training is provided to solicitors who are going to be on the staffing the youth hotline?
As a starting point, we have a training package and a solicitor hotline manual that includes references to legislation, other material that may be helpful and assist them. Following that, they generally have a one-on-one session with me, and I use that not only for training, but to make an estimate of their level of skill and ability and how much further training they may require prior to being rostered onto the hotline.
Is there scope for you to listen in on calls with solicitors for the benefit of improvement, or if there's a particularly difficult call, for example?
Yes.
How does that happen?
I often get calls from solicitors who are on the hotline who ring me and say, I've got this difficult case, what do you think? That happens on a fairly regular basis. So I'm available pretty much whenever it's running 24/7 to take those calls. There's other more senior solicitors in the office that are available if I'm not available. And there is, at least during office hours, an opportunity, especially for those solicitors who are still inexperienced, to listen in on those calls. And that's expected before they're placed on the roster and working by themselves.
You're aware from the evidence at the private examination that Miss Burkett gave evidence that there would be specific training on difficult situations with custody managers.
That's right.
Is that something that Legal Aid also does?
That's correct.
How does that happen?
That's generally me in the first training session that we do one-on-one. There's a range of examples that I'll go through with them about tricky situations that come up on a fairly regular basis.
Lastly, I'm going to ask you questions about what was described as the period of time that you were talking to a young person. Although there might be a segmented contact with the young person, is it correct to say that the first contact is likely to be through the youth hotline by a young person with the Children's Legal Service?
Yes.
But that's not the end of the contact, because the records that you prepare are then available for anyone else who might represent that particular young person. Is that correct?
They are available, yes.
And for those solicitors who do work with the Children's Legal Service, they are talking to young people on the hotline, and then they're talking to young people almost every day of the working week. Is that correct?
That's right.
And is there some specific training at Legal Aid or elsewhere about communicating with young people?
It's training we offer for every new solicitor that's part of the Children's Legal Service. Again, there's a training package. We make reference to a lot of different material, and that's followed up by on-the-job training with very strict supervision, normally while they're over at court, to make sure they're doing their job correctly.
That completes my questions, Chief Commissioner.
Could I just ask you about this, and this is a general topic. If court proceedings were going to be commenced, civil proceedings for a young person, say in the Supreme Court, for damages arising from an accident of some sort, or there is a legal requirement for there to be a tutor, an adult who is the tutor on behalf of the child. That is until the person turns 18, and then that person can exercise their own rights. That procedure, of course, is of no assistance at all by way of analogy with the present subject matter, because a call comes through and it's a young person held at a particular police station, possibly the middle of the night, and it's that person who's the client for the purpose of the conversation. That's
That's
so.
right.
And as you see it, it's the right of the young person, when one's talking about the right to silence, that needs to be explained.
Yes.
A support person may be a parent, they may be a guardian, they may be someone else. it may often be the case that it's hard to find a person to act as support person. That's a common enough experience, isn't it?
That's true.
But when the support person comes on the scene, is the nature of that person's involvement and the relationship with the young person really to be found in LEPRA and what it says in the LEPRA Act or regulations about the role of support persons?
Yes, there's a document there that I guess describes the role of a support person that's provided to them.
Yep. Whether the support person may be in a position to provide sound advice or unsound advice to the young person is always a matter of, it's an open question, if I could put it that way.
It is.
Do you know of any cases in your own experience or what you've heard through legal aid of the support person having a conversation with the police officer which may lead to what's said to be a change in mind leading to an interview as against the background where an interview was not to take place initially?
I have personally experienced that in our staff, but that's not normally something we find out about the particulars of that until we get to court. And it arises in the course of us taking instructions on a particular charge.
There happens to be an example of that amongst the decisions which are now in evidence, Exhibit MTS 69, Judge Nicholson in R versus APCR and R versus CP, a 2006 decision where Donna outlined at paragraph 82, and thereafter the police officer spoke to the mother and police officer said it would be in the young person's best interest to do an interview now and get it all cleared up. The mother then thought the detective seemed friendly, and as a consequence an interview took place. Have you heard of that type of scenario occurring?
Yes.
And there's a problem with that, whether it's in the interest of the child or not involves legal considerations too, including the rights that the legal aid lawyer gave some advice about.
Yes.
And is that a type of scenario where if there were circumstances changing of that type that it would be hoped, if not expected, that there would be an opportunity for further legal advice to be given to the young person?
In an ideal world, that would be my expectation.
Yes. All right, were there any questions arising out of what I've just asked?
Chief Commissioner, I just have one question
Yes,
that
yes,
came up
Mr.
as a result,
Yep.
a clarification. Mr. Farnham, in relation to this case, it's true, isn't it, that there was a fairly inexperienced solicitor on this file that was new to the area?
You mean the subject of the...
Well, the person who was in this particular matter, was he experienced or inexperienced?
I can't comment on that. I believe this list is from the Aboriginal Legal Service.
Sorry, which
that what we're talking about?
situation are you talking about, Mr.
Sorry,
Wolf?
Chief
We've got
Commissioner.
any number of ones in...
Sorry, in this
Courts have
particular...
been throwing these interviews out for some years, but you're talking about one of those cases or something else?
Mr. Whitting was fairly inexperienced to the area. He only just
Well.
come into the area.
Not sure if I'd...
Okay, I'll withdraw the question.
Well, what's the proposition you're putting? What's the assumption you want Mr. Frankham to make for the purpose of
But there wasn't
the
one of the
question?
experienced solicitors from his area handling this particular matter in relation to the understanding of the young person on the other end of the line.
I can't comment on Mr. Whitting's experience.
Thank you. No, nothing further.
One question, Chief
Yes.
Commissioner.
Yes, Ms. Lynn.
You, in the legal aid submission on page 8, it refers to a protocol that exists between legal aid New South Wales and New South Wales Police. What's your understanding as to why that protocol was set up in the first place?
My understanding is that protocol was set up as a model of best practice, both for the police and the solicitor manning the Legal Aid Youth Hotline.
And what does that best practice mean to you? What does that involve?
The best practice is setting out, I guess, what's expected of the police on every call, and also what the expectations would be on the solicitor who's taking the call.
And that protocol exists to ensure that young people receive independent legal advice, is that right?
That is part of it, yes.
Yes, thank you.
Anything further, Mr Fernandez?
No, thank you, Chief Commissioner.
All right. Well, thank you very much for your attendance today, Mr Frankham, and for your evidence and for the work that went into the submission. I'm conscious that it's yourself and your colleagues at Legal Aid who have put this together, and this is a topic of significance to the Commission, and the Commission is very grateful to Legal Aid and to the Aboriginal Legal Service for their efforts in putting together at relatively short notice very helpful documents.
Thank you.
Thank you. If you'd like to step down. Mr Fernandez.
Chief Commissioner, the next witnesses will be available at 10 a.m. tomorrow. They are Assistant Commissioner Cotter and then Assistant Commissioner Crandell.
Yes. Now, looking ahead, on Wednesday, there'll be a 9:30 start on Wednesday,
Yes.
and the Commission can only sit half the day,
Yes.
so we'll be stopping at about 12:30 on Wednesday.
The only witness called on that day will be Miss Hopgood, and we'll be starting at 9:30 on that day. If additional evidence needs to be given from Assistant Commissioners Cotter or Crandell and any other witnesses who give evidence on behalf of the police, that will take place on Thursday.
Yes. We'll see tomorrow whether the two Assistant Commissioners are in a position to deal with the range of questions to be asked, but if there is any issue in that respect, there'll be Thursday available, as
Yes,
you
that's
just
right.
pointed out. Right. Anyone wish to raise anything before I formally adjourn till 10 o'clock tomorrow? Right, well, the hearing is adjourned until 10 a.m. tomorrow.
Silence all stand.